objection in relation to your request is that this court directs that issues, if any, be raised upon delivery of the pretrial directions by this court, since clearly some of the issues raised in support of the request for adjournment may perhaps be covered by the pretrial directions. Summary of the pretrial directions. Pursuant to guidelines 5 and 6, the guidelines for active case management of criminal cases in magistrate courts and the High Court of Kenya, and in the best interest of effective case management underpinned by the overriding principle of disposing this matter fairly in keeping with Article 50 of the Constitution, without undue delay, in tandem with Article 52E of the Constitution, this court issues the direction set out below. Under Direction 2, this court has provided the mandatory information required by the Constitution to be provided to the accused persons, which I believe all counsel have already shared with their clients. And so I will not read paragraph 2. Under paragraph 3, the state shall be deemed to have complied with Article 50, 2C and J of the Constitution by doing the following. A, if any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present and the approximate time each witness is likely to take in examination in chief. B, if any, preparing a bundle of documents, binding them serially, save for the bundle of documents retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating all the documents serially, indicating the maker of each, number of pages of each, crowned with a table of contents, clearly indicating the corresponding page number of each document and the range of page numbers for each document. Where only part of the document is relevant to this matter, highlighting the relevant part of the document. C, the number and volume of documents cannot fit one bundle, the state is at liberty to serialize them in volumes. D, the prosecution is directed to serve the said tabulated list of witnesses and the bound documents upon the advocates representing the accused persons before the next mentioned dates. E, upon service and to acknowledge receipt, the said advocates shall sign against service of the said tabulated list of witnesses and band of documents. F, the prosecution is further directed to share with this court the following. Roman 1, the tabulated list of witnesses, and Roman 2, the tabulated list of documents only. G, this court underlines that all copies of the tabulated list of witnesses and the said bundle of documents held by all parties in this matter should be identical to the originals held by the state. Direction number 4, hearing of this case and interlocutory applications. A, hearing of this case will proceed on a day-to-day basis where so directed. B, on the days appointed for hearing, sessions will begin at 9:00 a.m. pronto, unless expressly advised or varied otherwise by this court. C, any preliminary issue which may hinder or is likely to hinder hearing of the matter or cause an adjournment should be raised in accordance with direction number 5 below. D, any special need, for instance, the need for any special attention to witnesses, intermediaries, interpreters, hearing or mentioned virtually, should be raised before the date appointed for hearing or mention. E, any emerging issue which is likely to hinder hearing or mention of the matter as scheduled shall be raised in accordance with direction number 5 below. F, on the day, and this one underline every word, on the day appointed for hearing, no application for adjournment will be entertained, and no adjournment will be permitted, except where exceptional circumstances evidently beyond the control of any party to this matter is demonstrated, as detailed under direction number 5 below. Now, direction number 5 in summary tells you what to do if you wish that the matter is taken out. So the taking out cannot happen on the hearing date. On application lodged on the hearing date. In summary, direction 5 tells you if you want to take out the matter, then an application in that regard should be served upon all the parties, should be filed and prosecuted prior to any mention of hearing dates. And that will help all of us on that question of trial certainty. Now, under direction 5, we have 4 kinds of notices. A, the first notice is a notice by this court that it will not be sitting. And of course, all notices, the 4 notices, must be brought to the attention of all parties prior to the date scheduled for mention or hearing. So the first notice you will expect from the courts. It will be fired on all platforms, including your email addresses provided, through your phone numbers, and through, of course, the notices, the usual notices issued by the court. And as I earlier mentioned, the purpose of all the notices is to mitigate inconveniences and reduce trial uncertainties. The second notice is a notice by the party, and this includes the DPP and the accused persons and their advocates. Except in exceptional circumstances evidently beyond the control of the party, no adjournment by ambush and no application for adjournment is permissive on the hearing date. Instead, the affected party shall lodge a simple application by notice of motion, highlighting the grounds upon which the party seeks to have the matter taken out of the cause list. And the court will schedule quickly a hearing of that application where all parties shall be invited to attend virtually. And the court, of course, will give appropriate directions on that question, including whether the hearing will proceed or not. The third notice is where an accused intends to withdraw instructions from the advocate. That cannot also happen on the hearing dates or on the hearing date. Sorry. That also requires a mention prior to the hearing date to dispose that issue. And the last notice expected is where an advocate desires to withdraw his or her services of representing the accused. That cannot happen on the hearing date. It must happen before the hearing date. But of course, all in this, you must file a notice for determination by the court before the hearing date. I've taken quite a while on that because that is where we have issues, but we are managing. Direction number 6, time management. Generally, each party is expected to utilize time considerately and reasonably. So in this court, I will not expect tautology and long stories. If you have a point to raise, this court is sharp enough to pick your point from the first word. So you do it. If you do it in one sentence, we will appreciate. We will not appreciate 1,000 sentences for one sentence. And from time to time, I'm now giving a summary of the several directions under Direction 6. From time to time, where court thinks that it is appropriate, it will fix time for a certain event. For example, for examination in chief, for cross-examination. But initially, the court will be very slow to fix time unless it observes over time and finds necessity to do that. Direction number 7 on evidentiary objections. As far as practicable, and this one also should be underlined from end to end. Evidentiary objections shall be deferred and raised upon completion of examination in chief, but immediately before the contested document is produced as an exhibit. Except, and I underline this one, where the objection is of such a nature which cannot be deferred to that stage. Of course, we have categories of objections which can be deferred. We have those, for example, on the lines of examination which cannot be deferred, which must then be raised immediately. What then must you do in that regard? If you have an objection, record it, keep it. Let the witness complete. Then raise all your objections in one opportunity before that the subject document is produced. And that usually happens upon proposal that the document is about to be produced. This is another area where we need help, which wastes a lot of time in court. B, and this area has not been utilized that way. The court expects that where you have objections or you desire to raise objections, you shall have tested those objections with your counterpart and consider whether there can be a consent under 159(2)(c) of the Constitution. I don't know why parties are not utilizing 159(2)(c) in regard to objections. And I've seen this work in some few cases where you think this one and this one is likely to bring issues. You run it against your counterpart. And sometimes the counterpart will tell you, we may not even produce this document, or we will do this and that. So that I utilize Article 159(2)(c) to have consents on areas where you think there may be objections, which may delay the matter. Direction number 8, which should also be underlined end to end, is on plea bargaining. Without prejudice to the right to be presumed innocent until the contrary is proved, as guaranteed by Article 52A of the Constitution, and pursuant to Article 159(2)(c) of the Constitution, which obligates this court to promote alternative forms of dispute resolution, read in sync with both the Criminal Procedure Code, check sections 137 capital A through 137 capital O of the CPC, read further in sync with the Kenya Integrity Plan 2023-2028, which too obligates this court to promote alternative dispute resolution mechanisms, and read further with the ODPP Plea Bargaining Guidelines 2019. Parties are at liberty to pursue plea bargaining where this is appropriate. Direction number 9 is on lead counsel. In circumstances where the accused person is represented by more than one advocate, all the advocates shall be led by one lead counsel of the accused's choice, who will substantially be in conduct of the matter for and on behalf of that affected accused. And the team of advocates, where necessary, will play a supplementary role. Direction number 10 is on allocation of alternate prosecution counsel. In order to ensure continuity of the matter and mitigate the chances of adjournment or delay on account of unavailability of prosecution counsel, the DPP is encouraged to allocate at least 2 alternate prosecution counsel who will be required to be equally familiar with the matter and ready to proceed at all times. Direction number 11 is on the obligation of the accused and their counsel to respect the sub judice rule. This is self-explanatory. I will not read the complete direction. Direction number 12 is attempting to or engaging in acts which may unlawfully compromise the integrity of the process. This code does not entertain attempts or acts which may unlawfully compromise the integrity of the process. Of course, that is also self-explanatory. And direction number 13 is on variation of these directions. These directions may be varied by this court either sua sponte or upon motion of any party, supported by cogent reasons. Ladies and gentlemen, these are the ground rules which will guide the process. And at this point, I will invite parties to raise any issues, including now Mr. Peter Wanyama, if there are any issues which can come after directions.